This wasn't just another headline buried on page 7. This was an 8-to-1 bombshell from the US Supreme Court, one that just flipped the entire gun rights chessboard. Missouri stood up, passed a law meant to protect gun owners from federal overreach, and what did the Supreme Court say? Nope, denied, crushed. Sidelined with barely a whisper. Only Clarence Thomas stood with Missouri. The rest, silent, cold, gone. Now here's the real kicker. This wasn't about some technicality or narrow statute. This was about whether states like Missouri can shield their citizens from federal gun laws they believe are unconstitutional. And the highest court in the land just said, not today. But wait, this isn't the end of the story. Because Trump's own legal team, they jumped in, but not how anyone expected. Instead of backing Missouri all the way, they played a game of legal gymnastics, and folks are still trying to figure out why. Behind closed doors, a battle is raging, not just in the courtroom, but in the very heart of what federalism means for gun owners. The idea that a state can say no to Washington when it comes to your right to bear arms is on life support. And yet, there's more coming. On September 29th, all 9 justices are meeting in secret. No cameras, no transcripts, just whispers behind thick marble walls. They're deciding whether this case lives or dies, whether Missouri gets a fair shot, or if this 8-to-1 beatdown is the final word. So yeah, this isn't just legal drama. This is the most important Second Amendment showdown since Brune. And if you thought gun rights were secure, think again. You're about to see how fast the ground can shift beneath your feet. More coming next. What actually happened in that courtroom, and why it's got every 2A supporter talking. The real detonation came from the 8th Circuit. After Missouri lost in district court, they hoped the appellate judges would at least trim the damage. Instead, the court went nuclear. The 8th Circuit didn't just strike down part of the Second Amendment Preservation Act, they torched the whole thing. And not because of its mechanics, not the $50,000 penalties, not the police non-cooperation causes. What they went after was the law's intent, protecting gun rights from federal overreach. That's where it gets dangerous, because now any state law that dares to resist federal gun enforcement, even if it's written differently, could be dragged under the same precedent. The 8th Circuit's message was loud and clear. If your law smells pro-Second Amendment, it might just be unconstitutional. Worse, their ruling left no room for surgical fixes. Missouri's legal team says a simple Rule 60B motion in district court won't cut it. Why? Because the precedent is already set. Lower courts have to follow the 8th Circuit's logic. Even if Trump's DOJ tries to soften enforcement, it's meaningless if every judge below the Supreme Court treats any gun rights preservation law as poison. Missouri knew this wasn't just their fight anymore. It was a lit fuse, burning fast, that could blow back on every red state trying to stand its ground. Trump's DOJ finally stepped in and stumbled. Instead of backing Missouri, they waffled. They admitted the 8th Circuit went too far, but still told the Supreme Court, don't take the case. That's like spotting a fire, then asking firefighters to let it burn. Missouri's lawyers called it out. If DOJ thinks the court messed up, why run from review? Simple. They don't want a Supreme Court ruling on this. Too risky. Instead, they're gambling on a quiet fix with duct tape in the lower courts. But even if that works, the 8th Circuit's logic remains. It's not strategy, it's surrender. And Missouri's left standing alone, betrayed by the very team that was supposed to back them. Let's rewind the clock for a second. Before this whole thing exploded into a Supreme Court mess, Missouri had already taken a legal beating. Their state-level gun rights law, the most aggressive anti-federal enforcement measure in the country, got nuked, not once, but twice. First stop, District Court. Boom, entire law wiped out. The judge sided with Biden's DOJ, calling the law unconstitutional from top to bottom. Missouri didn't blink. They appealed straight to the Eighth Circuit and fired off an emergency SOS to the Supreme Court, basically saying, "We're taking this higher, but in the meantime, don't let that lower court ruling kick in. It's gonna cause serious harm." And what did the Supremes do? 8-1. Only Justice Clarence Thomas said, "Yeah, I think Missouri has a point here." Everyone else, including the usual conservative heavy hitters, flat out denied the emergency relief. Just let the ruling stand. That sent a shockwave through the gun rights community. Because remember, this court had just handed down Brune. They've been on a Second Amendment hot streak, and suddenly, they freeze up? That's when folks realized this fight isn't just about gun laws anymore. It's about something bigger. How far can a state go when it wants to defy Washington? And this court? They weren't ready to answer that. Not yet. Now here's where things take a weird turn. Just when Missouri thought they had one last shot at getting the Supreme Court to fully review the case, Trump's own Justice Department dropped a legal bombshell. After months of silence and delay, they finally responded to Missouri's position, and it wasn't what anyone expected. Instead of standing fully behind the state, the way gun rights supporters assumed they would, Trump's DOJ played it down the middle. They admitted the lower court might have gone too far. They said, yeah, maybe the district court overreached a little, blocked too much, and maybe Missouri's law still has some legal room under the anti-commandeering doctrine. But here's the twist. They still told the Supreme Court, don't take the case. That's right. Trump's legal team is essentially saying, we know the Eighth Circuit made a few mistakes, but we'd rather fix this in the lower courts ourselves. Why? Because letting the Supreme Court step in now risks locking in a bad national precedent. They're trying to dodge that bullet, even if it means leaving Missouri hanging for the moment. It's a chess move, and Missouri's lawyers were furious. Their latest filing basically calls this strategy cowardly. They argue that if Trump's DOJ really believed the lower court got it wrong, they should be begging the Supreme Court to clean it up, not running scared. And just like that, the fight got messier. Missouri didn't waste time. Their legal team came out swinging, accusing Trump's DOJ of playing both sides, admitting the lower court's ruling is flawed, but still resisting Supreme Court review. Missouri's argument cuts deep. They point out the real danger. The Eighth Circuit didn't just strike a few parts of the law, it torched the whole thing, not because of the wording or mechanics, but because of its motive, protecting gun rights from federal overreach. That's a legal landmine. If courts start striking down laws based on political intent, not structure, it's open season on any state pushing back against Washington. Missouri says that's why the Supreme Court can't sit this one out. Even if Trump's DOJ files a 60B motion in district court, something they've floated, it won't undo the Eighth Circuit's precedent. Lower courts are still bound to follow it, and unless the Supreme Court clears the fog, that decision lingers like a legal ghost, haunting every state that dares write its own gun laws. So now we hit the part no one saw coming. Missouri thought they had one last shot to save their Second Amendment law. Then Trump's DOJ stepped in and dropped a political smoke bomb. Instead of standing tall with Missouri, they tiptoed. They admitted the district court might have gone too far, then turned around and told the Supreme Court, yeah, don't take the case. Seriously? Their plan? Keep it buried in the lower courts, where outcomes are easier to steer. That's not defending the Constitution. That's playing cleanup. Missouri didn't mince words. They called it what it was. Cowardice. Because if the DOJ knows the ruling was wrong, why run from the fix? Simple. They'd rather slap duct tape on the crack than rebuild the foundation. Missouri came out swinging. No gloves, no filter. They torched the DOJ's strategy, calling it what it was, a political dodge. And they asked the question no one in DC dares. If the feds agree the Eighth Circuit got it wrong, why beg the Supreme Court not to fix it? Because this isn't about Missouri. It's about killing the idea that states can defend gun rights at all. Missouri's law was struck down not for what it did, but for why it was passed. Supporting the Second Amendment? Treated like a crime. So Missouri issued a warning. Let this ruling stand, and it becomes law for every lower court. Think your state is safe? Think again. This is a legal time bomb, and Missouri just pulled the pin. All right, buckle up. After months of radio silence, Trump's DOJ finally dropped their response, and it shocked everyone. Instead of backing Missouri to the hilt like most expected, they played it safe. Real safe. Too safe. They didn't fully defend the lower court's ruling, but they didn't want the Supreme Court touching it either. So what's their game? Control. They're trying to keep this whole mess bottled up in the lower courts, where they can micromanage the fallout. Their filing basically says, yeah, the district court might have gone a little overboard, but don't worry, we'll clean it up ourselves later. Translation: they don't want to risk the Supreme Court setting a new precedent that limits federal muscle. It's a legal retreat dressed up as a strategy, a calculated move to dodge a high-stakes showdown. But in doing so, they've left Missouri and every pro-2/8 state hanging in the wind. This all traces back to a brutal losing streak in Missouri's own backyard. When the district court first struck down the state's gun rights law, they didn't just trim it, they lit the whole thing on fire. Gone in full, no half measures. The ruling sided squarely with Biden's DOJ, calling the law unconstitutional from top to bottom. Missouri didn't wait. They sprinted to the 8th Circuit, hoping to pause the wreckage during the appeal. That's when the Supreme Court got dragged in with an emergency stay request. Missouri warned that keeping the law blocked would cause irreparable harm, sweeping immediate consequences for local enforcement and state sovereignty. But the Supreme Court wasn't buying it. They shut Missouri down with a gut-punch 8-1 vote. Clarence Thomas stood alone, waving the flag for states' rights, while every other justice, left and right, let the lower court's ruling stand. That wasn't just procedural, it was a message, and it echoed across the entire legal battlefield. That ruling didn't just sting, it was a gut punch. After Missouri's emergency request got shot down by the Supreme Court, the case charged back into the 8th Circuit like a cornered beast. The court didn't waste time. They fast-tracked oral arguments, and when that final ruling came down, it was brutal. Missouri's entire law wiped out again. But this time, the court didn't just shed the law's mechanics, they went for the heart. The judges claimed the very reason the law was written, to protect gun rights from federal reach, made it unconstitutional. That's right, they torched the law not because of what it did, but because of why it was passed. Let that sink in. The intent behind pro-gun legislation is now on trial. That flips the game completely. If courts can now crush a law for just defending constitutional rights too boldly, what does that mean for every other state trying to draw the line? For Missouri, it wasn't just a loss, it was a flashing red warning. They knew the only chance left was to take the fight straight back to the top, the US Supreme Court. But the clock was ticking. So Missouri regrouped and fired off a formal Supreme Court petition, this time swinging for the fences. Their argument? This wasn't just about some overreaching state bill. It was about preserving the basic right of states to push back when Washington crosses the line. They hammered the 8th Circuit's logic as flat-out dangerous. If a law can be nuked just because it was inspired by defending gun rights, then any state daring to stand up for the Second Amendment is at risk. Missouri warned, this ruling doesn't just gut our law, it creates a ticking time bomb for every other state trying to protect their own people from federal overreach. But just as things were heating up, a curveball came flying in from Trump's own Justice Department. After months of silence and delays, the feds finally filed their response. And what they said, nobody saw it coming. Instead of backing Missouri like many expected from a Republican administration, Trump's team pulled a political juke move. They admitted the lower court might have gone too far, sure, but then turned right around and told the Supreme Court, nah, don't take the case. That's right. The Justice Department basically said, yeah, the 8th Circuit kind of overreached, but let's just fix this mess quietly in the lower courts. To say this caught gun rights advocates off guard is putting it mildly. It wasn't a full betrayal, but it wasn't the cavalry charge they were hoping for either. This wasn't a slam-dunk defense of state sovereignty. It was legal damage control. The strategy? Avoid rolling the dice at the Supreme Court. Keep the fight contained, controlled, and away from any ruling that might reshape federal power, for better or worse. But Missouri wasn't having that. Not by a long shot. So no, this isn't just Missouri's fight. It's every state's last stand against federal overreach. A line in the sand that, if crossed, changes everything. If the Supreme Court turns its back, the Eighth Circuit's decision becomes the blueprint. And the message to every state? Sit down, obey, don't resist D.C. On September 29th, 9 justices meet behind closed doors. No cameras, no press. Just one decision. Do states still have the power to defend your gun rights or not? So don't just watch. Share this. Subscribe. Stay loud. Because if this ruling holds, it won't stop with Missouri. And if they think gun owners will stay quiet, they've got another thing coming. The battle just moved to the highest court in the land, and this war is far from over.